Good morning. So this is Cincy Guao. I probably pronounced that wrong. I apologize. Versus Ronald Dancy, Heritage Bank as garnishee. This is June 2nd, 2023, the 10 a.m. hearing. Mr. Moranchik, did I pronounce that properly?
Close. It's Moranchnik. Good morning, Your Honor.
Moranchnik, sorry. And Mr. Dancy are present. And this is about a garnishment. Garnishment has begun. There are funds in the registry, and Mr. Dancy has presented information regarding the type of funds and that they may be exempt from the claim. So, Mr. Dancy, I'm going to go ahead and let you start since this is your motion.
Okay. I submitted some paperwork to the court, Your Honor,
I received it.
with the evidence of my disability from the Veterans Administration. The other thing is that Mr. Moranchnik and Mr. Kuo sued me personally, but they took this money from the business account. So I'm not sure how that works as far as this garnishment goes. But the money that was...
Let me ask you this. So my understanding is that your claim is that these are veterans benefits. Is that correct?
Well, the income from that was helping me buy my medicine and all that other stuff that goes in.
Answer one question at a time, because garnishments aren't my bailiwick. So you're going to have to let me walk myself through this, okay? All right. So it is my understanding that your claim, your traverse of this claim is that it's about the money that was taken out was based on 100% disability that you got in December of 2022, which made all of those veterans benefits. It went from 10% to 100%. So all of those veterans benefits, you have 100%.
100%. 100%.
Right. And you were receiving those veterans benefits, and you're alleging that those were that was the money that was taken from the account. Is that correct?
No, that's not the money that was taken from that account. No, what I'm claiming is that the money from my income, some of the income was taken from that account that I used to purchase medicine, to pay some other things, my living expenses and so forth.
Well, let's talk about your business. What kind of business do you have, Mr. Dancy?
Well, what we were doing over there, we had an automotive shop and we had a parking lot. We had approximately maybe 60 clients that parked on the property that we drew funds from. In March, in the end of February, when our lease expired, I had no conversation with Mr. Kuo as to whether or not we were going to go forward with the lease or not. The first time I ever met Mr.
So we're not here for that part, because that part, that Judge Shalonda Jones Parker, that ship has sailed. She said that an amount of money is due, and that amount was $80,716.33, which breaks down to $69,549.05 in principal, $96.92 in post-judgment interest as of the time that it was filed, and $10,851.36 in other fees, meaning attorney's fees and court costs. So now here's the confusion that I have. So I have that you are the defendant individually, but you keep telling me about a business. And what I want to be sure is that if you are commingling funds, your veterans benefits are going into the same account as your business money, then that's an issue, because if they're going to take money that is quote unquote income, they're allowed to take that. Veterans benefits, not so much. But the issue is when you are commingling those funds, then it becomes hard to determine what's an individual income amount and what is a benefit amount. And business funds and income should always be separate.
Gotcha.
So
I guess we revert back to
100% of what you're talking about may not be veterans benefits.
Right. And okay, the other issue is if that's the case, they sued Ronald K. Dancy. So how do they take from Reunited? Reunited's nowhere on there. The name Reunited Automotive is nowhere on this case. So
Okay,
why are they taking
once
funds from Reunited?
again, you're talking about something that was decided by Judge Jones Parker. I cannot undo what she did. You can
Yeah,
go
but
back to her to challenge her judgment on certain things, not a lot. There's not a whole lot you can do to traverse a judgment once it's been imposed.
mhm,
However, now that you're here with me and it's the garnishment, that's a different view. I got to look at some different things, okay?
yeah,
So it appears to me that Judge Jones Parker felt that you and Reunited Automotive are one and the same, so that there's no appreciable difference between you, your business, your individual funds, and the business funds. And what you've said to me kind of undergirds that, because you've said that you've used money in this account to pay for your medicines and things of a personal nature, even though it is a business account.
mhm, yeah,
So when things are commingled in that way, or when a judge feels like the corporate veil has been pierced, and you are the same as the business, then the amount of money is coming from you. Now, I'd like to understand what part of this is veterans benefits so that we are not doing something improper, but it's hard to see where the dividing line is.
mhm. Well,
Okay.
there was no money going into that account from my veterans benefits. It was just
Okay.
work income. Yeah.
All right. Well, then it seems that there's no reason to keep that $11,664.58 from Mr. Marachnik's clients. Let me hear from him, sir.
Thank you. Thank you, Your Honor. Again, may it please the court, Paul Marachnik. I represent Jin Guo. So the veterans benefits is really an easy decision. I've spoken with the bank. I've been provided with bank statements. There's no evidence whatsoever that any veterans benefits were being deposited to that account. In fact, as Mr. Dancy has stated, if he's using that account as a business account, it would in fact be improper to have benefits deposited to that account. That's number one. The other thing is, just as an aside, a financial institution is obligated to proactively exempt certain federal benefits, and that includes veterans benefits, it includes Social Security, it includes disability, pension, railroad pension benefits, those types of things. So the bank is actually obligated to do that. When they're served with a garnishment and an account receives federally protected funds, then they have to perform a look back for 60 days and see what was actually deposited in those 60 days. So we assume that the bank already does that. I do know in having obtained bank statements for 90 days that there were zero federal benefits deposited to this account. And I think Mr. Dancy has confirmed that, in fact. So the other issue, since we've disposed of the disability benefits issue, the other issue is whether this is a business account. So there's no evidence in the record or before the court today that this is a business account, other than Mr. Dancy stating that he uses this account for business. So a business account in and of itself does not mean that it's not his account, right? You can open a business account in your name, and you can open it, you can call it whatever you want. And I believe he has called it, something automotive. So the
Reunited Automotive, sir.
Thank you. So the clarification that he provided that sort of proves my entire point is that he has stated that he's been using this account to pay for medicine, to pay for living expenses. And that is just, by definition, commingling business and personal funds, even if this is an entity, which again, there's no evidence that this is an entity. So I don't believe there's anything before the court today that either there are federal benefits that are being tied up that should be exempt, Not only is there no evidence, I just know that there are no benefits in this account. And number two, there's been no other claim asserted, whether by an entity or anyone, that these funds are otherwise not subject to garnishment. The last issue that I wanted to address just very briefly is Mr. Dancy had claimed on his claim form that the amount that we were seeking is incorrect. I don't know if he is maintaining that claim or not, but the amount that we have sought is the amount of the judgment plus an additional $96.92 in post-judgment interest for essentially 4 or 5 days. Looks like 4 days, and then the garnishment fee itself. So I don't know what basis there is to challenge the amount that we're seeking. I'm not sure that the amount we're seeking matters because the amount that has been tendered into the court is significantly less than the amount that we're seeking.
Yeah. All right, Mr. Dancy, anything on that point?
Well, he says there about the garnishment, ma'am. There was no order for a garnishment when that garnishment was taken out by Mr. Marachnik. I called the court and they said there was no garnishment there. But I'd like to challenge that. The other thing I'd like to challenge is the fact that the business count, there is a business count. There's an EIN number. We were conducting business over there. I understand what he was saying about commingling. I'm not sure about how that commingling thing works. Or even what
Mr.
it
Dancy,
means.
let me explain that part to you. So I spent a lot of time when I was a magistrate judge, kind of teaching business law. And that's the thing that is hard for judges and lawyers, because business people don't always think the way we think. And we're taught that certain things should and shouldn't happen when you're establishing a business. But a lot of what I would see is that people think that if they open an account and call it whatever money they put in there, whether they're spending it for the business or whether they're spending it for household or whether they're paying for medicines, they can use it for whatever they want to use it for at any given time. So if I open my account, let's call it Judge, and that's my business. But I'm putting my income in that. I'm putting my paybacks from loans that I've made to people individually. I'm getting money back from being a judge. I'm putting in all of this into the pot. The problem then is you look past the account to determine whether there is actually a business that is a separate entity from the person. And for there to be a separate entity, certain things have to happen. So not just an EIN number, but you have to have certain indications that this business could stand on its own. Even if something happened to you or you went away and somebody walked in, they could still operate this business. And there's no indication of that. Usually those things are that it has a registration with the Secretary of State. It has a name that is like registered with the Secretary of State, and no other business has that name or does business under that name. It has directors or people who are in charge of running the business, and they are listed as such. Even if you're putting money into that account, what you try to do is make sure the money coming from that account into that account is only money that is made in the course of business. And that's where it comes to what we call commingling funds or piercing the corporate veil. So I've briefly read Judge Jones Parker's order, and what it appears to me is that even if there was a consideration that there was a reunited automotive name or entity in some sense, what she determined was that it wasn't separate enough from you as an individual, that the corporate veil had been pierced, and so you and United are one and the same, and so the money coming out of that account is money that is available for the garnishment. Now, that was my understanding of it. Mr. Marachnik, have I made a mistake in how I framed that?
Well, I'm not sure that much matters, Your Honor, because there's two other points that I think are important. And one is that to the extent there is an entity, and I don't know if there is, but if there is an entity, That entity is not in court today. That entity has not filed a claim. That entity has not filed a traverse. That entity has not asserted that it has any rights to these funds greater than the garnishing plaintiff. That's number one. Number two, under the garnishment statute, a plaintiff can get to funds in an account that is not the account of the defendant if the defendant is using that account for an illegal or improper purpose. And I think based on Mr. Dancy's statements today before the court, it's very clear that if this is an entity account, that he is clearly using those funds for an improper purpose if he is using the money to pay for his personal expenses. So that, again, the claim isn't before the court, but I think that's the background and analysis that's important if the claim were before the court.
I think something's going awry here, Your Honor.
Yes, sir.
I'm entitled to pay myself, and I think out of me paying myself, if I stated it wrong, I do have the right to use my own money from my pay to buy my medicine. So I think something's going wrong here, and I think it's a misunderstanding.
Well, it's in the sense of, okay, so I understand what you're saying.
Yeah.
But Mr. Moronchnik is making a more technical argument, and that argument is what would be asserted is that the business says you're taking funds that are not available to you because those funds belong to the business. Even before you pay yourself, they belong to the business. That's
not what I did, Your Honor. That's not what I did.
Well, I don't know that
it may appear that way, but that's not what I did.
Okay,
paid myself. I paid myself a salary. I used my own money to buy my medicine. Okay. I'm entitled to that, I think.
And you put that money in a separate account?
Yeah, of course.
Your Honor, if that were a couple points, again, number one, there is no entity making a claim before the court.
I get that, Mr. Moronchnik. That was going to be part of this, Mr. Moronchnik, is teaching, because a lot of times people don't understand, and garnishments are hard even for myself and Ms. Fortson. So a lot of it is teaching. So, Mr. Dancy, what the argument that he's making is that even if what you're saying was the case, the business is not here as a separate entity to assert its claims. So if you are saying that Reunited Automotive had money that was not part of the garnishment, then Reunited Automotive as an entity would have to be here. But there's an aside to that is very important. Reunited Automotive as a company may have to be represented by an attorney and have a separate, because their claims would be separate from yours. But their claims aren't here before me because they're not here. You haven't asserted a traverse on their behalf, and neither has an attorney. So do you understand that?
I do, but it seems like we're contradicting ourselves, because at the onset, we said Reunited and Ron Dancy were one in of itself. That's what I heard.
No, I said that in the sense that you said this is the bank account named Reunited.
Right.
Right. But Reunited's not bringing a claim. Ron Dancy's bringing a claim. And if Ron Dancy is using Reunited's bank account as his own bank account to pay for personal things, then I don't have to worry about Reunited. I'm only worried about Ron Dancy. Even though the bank account is called Reunited, it's really not. It's yours.
Your Honor, if I may, there's also no evidence before the court to support what Mr. Dancy has said, because in fact, I mean, if we're just testifying about information without any evidence to support it, I've seen bank statements. There are no paychecks to Mr. Dancy. There are just withdrawals. There are
just. You have them, sir? Do you have those bank statements?
There are.
I don't mean to cut you off, but do you have them?
I do have bank statements.
Because there's some things on the bank statements I would like the judge to see. It really doesn't have anything with this hearing, but there's been a lot of lies told. There was a $6,000 payment at the end. There's no bank or anything signifying that or matching that. So if you have those bank statements or those checks, if you would, could you present them?
Hold on, Mr. Dancy. So
Yeah.
here's the issue. The traverse that you made was about veterans benefits. And so
Right.
I'm resolved in what Mr. Marachnik has said, and I did a little research on this, and the bank's responsibility to separate those funds, and they come labeled like your veterans benefit check is not going to look like any other check. So I am secure in my understanding that the $11,000 that currently resides in the registry of the court is the property now of Mr. Marachnik's client. So that's what we're here about, and that's the only argument that I am really supposed to consider, because that's what's before the court. Now,
Gotcha.
you're bringing in a lot of other arguments, but they're not supported by the filings that you've made. Okay.
Gotcha. Yeah. Okay.
All
I'm
right.
fine with it. I'm good with it. I'm done with this.
All right. So the court will deny the claim made, and will also require that the funds be released from the clerk's office and to the plaintiff. Is there anything else, Mr. Marachnik?
No, Your Honor, other than to ask if you need me to prepare an order, or
If you would, that would be great.
Sure. And should I send that to Ms. Heath-Borson?
Yes, and please include Mr. Dancy. Mr. Dancy, you have an email address, sir?
Yeah. I think Mr. Marachnik has it.
All right. So please include Mr. Dancy on the email. Let's verify. You have it, sir?
I think I do. Yeah.
Okay.
Yeah, I do.
All right. So at this time, the court is ruling in favor of the plaintiff. The order will be reviewed and signed, and then we'll disperse that order to each of you, and the funds in the registry will be ordered to be dispersed to the plaintiff. Okay.
Thank you, Your Honor.
All right. Thank
They would
you.
be
Thank you, Mr.
excused.
Dancy. You may.
You're welcome.
Thank you.
Thank you.